by Timberlake, League and Brooks, which pays an advertising fee to this station.
This is WAAY 31 Law Call.
Hi, welcome. I'm Robert Lane sitting in for Sharon Doviet, and this is WAAY 31 Law Call. Well, we got a little business to take care of tonight. It's Ask Us Anything, but we need your phone calls to make that all happen. 256-536-0077. We also have a video segment, You Make the Law Call, and Michael Timberlake is here from Timberlake, League and Brooks.
Here we go.
Hey, so now you specialize in hurt people.
Yes, we do personal injury work. So if you're bleeding or broken, basically we can help. But I have been practicing law for 30 years in Tennessee Valley.
You can pretty well tell me.
I kind of know my way around.
Well, and speaking of Tennessee, you now have a license in Tennessee.
We do have a license in Tennessee. We have four of our five lawyers are all licensed in Tennessee, and we have a pretty healthy practice up just north of the border.
Well, while you're making those phone calls, see that number, 536-0077, we're going to take a look at a little piece of video. Now, you want to keep your eye on the lady in red here, and
Oh, bless her heart.
Okay, now she wasn't hurt.
That's good.
I'm happy to
That's
say.
good.
But what I want to know is if that's a personal tree on someone's property or a
Right.
public tree in somebody's park.
Yeah, exactly. In this situation, you look at it and you say, okay, well, look, if this is a public area, if this is a place that is maintained by, a corporation, or if it's an apartment complex, if it's a common area, something like that, then those people have a duty or an obligation to inspect and maintain the premises in a safe condition.
Even though it's snowstorm.
Right, yeah.
Okay.
Even though it's a snowstorm. So, but what you're really looking at in this situation is this a foreseeable incident? Which means, is this something that the owner of the tree knew or should have known was going to occur? And if it is, then you can look at them as someone that's potentially liable for damages that result on it. Even if it falls on somebody else's property. If they knew or should have known that this was likely to occur, if the tree was dead, if the tree was dying, if the tree was not, was obviously not healthy, then in that situation, they're potentially liable for the harm that's caused.
Okay, but now the city has certain laws that protect it from...
Sure. City has, everybody has laws that protect them if property is open to everybody for a recreational use. So that's one of the things that comes into play, and cities can take advantage of that as well. The other thing is the cities do have immunity. So typically cities have a liability cap. In Alabama, the cities, municipalities have a $100,000 liability cap. So even if they cause injury to someone, they're only liable up to $100,000.
Now, give us a call, 536-0077. We did have a question about dog bites.
Yes.
So in Alabama, certain dogs don't get a free bite?
Well, I mean, it kind of goes back to the same situation. Is this a danger that the owner of the dog knew or should have known about? And if it is, then the dog owner is going to be liable if the dog hurts someone. So, colloquially, we call it the first bite rule. Every dog gets one free bite, which means that after a dog bites someone, the owner is on the hook or on notice that that dog is dangerous or has dangerous propensities and could injure someone. So if the dog engages in any kind of activity that makes the owner know that it's dangerous or would hurt someone, then the owner is liable for the actions of the dog if they fail to keep them restrained, or if the dog's on their property and it injures someone that's authorized to be on their property. There's one particular case in Alabama came out and said, look, if a dog is a certain breed, which is basically they had talked about pit bulls, Dobermans, other types of dogs that have dangerous propensities. If the dog can be deemed to have dangerous propensities based upon the breed alone, then they don't get one free bite. the owner has knowledge of the dangerous propensities of the breed, and therefore they are on the hook.
And do they list those breeds?
They mentioned some of the breeds,
Okay.
but there was an exhaustive list, and that's kind of been a point of contention for some of these claims. And then, how do you prove, what breed of a dog is? I mean, most dogs are mutts, right?
Right.
And so, are you talking about purebred? Are you talking about this? What would the court mean by breed?
Well, this is good for job security for you, you can find it out there.
There's always a gray zone.
Listen, Ethel from Athens, you have been very patient. We are very glad that you called tonight. I hope your Super Bowl team won. What's your question? You with us, Ethel? Let's try Angela from Decatur. Hey, Angela.
Well, there's Ethel.
It must be.
Angela? No, I hate that.
Listen, I understand that we here in Madison County are trying to get a public defender's office.
Right.
Explain to me what that means.
Well, so basically the way that if you are charged with a felony and you cannot afford an attorney, then the Constitution provides that the state will appoint an attorney for you to represent you. Traditionally, we have in Madison County we have allowed the court to appoint certain attorneys. You can petition or you can list yourself to be on the list of appointed attorneys, and as long as you meet certain qualifications, then the court will put you in the circle or the cycle to have you appointed, and then the state would pay these attorneys based upon an hourly rate for out-of-court time and a hourly rate for in-court time, and it's like $40 and $80. So it's very, very minimal when you're dealing with comparative legal services. But these appointed lawyers would take these cases and handle these cases. Well, the Madison County has decided, there's a commission that's decided to move to a public defender's office, and instead of appointing individual attorneys to represent indigent defendants, then they're going to pay with tax dollars for an office of a staff for attorneys to represent these clients.
And is that usual in Alabama?
It's in most cities they have them. Most of the larger cities have one. I think Huntsville is the largest city in Alabama that doesn't have a public defender's office.
Since it's the largest city and it doesn't have one, that would be true.
Right.
Listen, you're surprised, but Angela is back.
Okay,
yes,
great.
Angela, what's on your mind tonight?
Hi. So my husband recently passed away, and
Very sorry.
the mortgage is only in his name, and I'm in the middle of taking care of items and agenda, but the deed is in both of our names, and I do have the paperwork that it is in my name as well, so I do get ownership with the mortgage company. But my question is, I'm seeking different homeowners insurance. Do I need to wait, because I do have a probate also involved, do I need to wait until that's cleared, or can I change homeowners insurance currently, because I'm trying to lower my cost of bills?
Right. Well, that's a good question. So basically, from what you described, I'm presuming that the property was held with what we call joint tenancy with right of survivorship. And basically what that means is there are two people that are listed on the deed, and what happens is if one of them should pass away, then their share automatically goes to the other party, and vice versa. So your husband passed away, based upon the language in the deed, you are the owner of his half of the property. Now you are now the owner with the bank because the bank has a mortgage, but in terms of who has title to the property, you're the one who has current title to the property. So you're the one that's going to need to insure the property. And if it's joint tenancy, it passes outside of the estate. So even though if you probate, if you've got a will and you're going through some things with probate to probate his estate, this property is not included in that process. It passes outside of the estate. So what you're going to need to do is make sure, yes, that you have insurance on that property. You are the person that has the right to have insurance on that property. The mortgage company is going to insist that you get insurance on the property and that they're named as a secondary insured or primary insured on the property. So you want to make sure you deal with that. And then basically go talk to the mortgage company about refinancing in your name only to make sure that you can get financing for the property.
Well, Ethel really does want to talk with you. She has called us
We
back.
got their callbacks. That's great.
Ethel, what's on your mind?
Well, I was wondering,
You're on the air. You just listen to your phone, not the TV.
I was wondering if you have a will, do you need a trust, and what's the difference between a will and a trust?
Oh, that's a good thing. Well, basically the difference between a will and a trust is something that you can put assets in during your lifetime, let someone else take control of them, and then they can disperse them to someone else, or they can belong to someone else once you're gone. A will comes into play once you're gone, and it basically disperses your assets. Most people in Alabama only need a will. If you play your cards right and you name beneficiaries to bank accounts, or you name beneficiaries to investment accounts or 401k accounts, and then you hold property with right of survivorship like we just talked about, then you may not even need to probate a will. But the best thing to do is get a will, and that's more than likely going to be what you need in Alabama to do what you want to do when you pass.
Now, did you learn all of this from your father? Because, I mean, he practiced forever.
I did. So my dad's practiced for 63 years, and he kind of had a general practice and did a good bit of real estate. So he was my, he would be the person that I would call.
God bless you. Now, Leah, if you'll just hang in there, we got to take a break, but I promise we'll get to you. Just hang in there.
Provided in the public interest by Timberlake, League & Brooks, which pays an advertising fee to this station.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
It is Ask Us Anything tonight, so give us a call. The number is 256-536-0077. Michael Timberlake is here. I wanted to mention something that Timberlake League and Brooks does. They provide free wheelchair service to all the Broadway Theater League performances.
Yes. Yes. So when the Broadway Theater League has performances that, I guuld say start in the fall and run through the spring of every year, and this is a service that we do for the community, and we enjoy the shows. We enjoy the camaraderie with the folks that do it. We enjoy the wheelchair races that we get to have every so often. But we really do. It's good for the community, and it's a fun thing for us.
And it's absolutely free. You just call Broadway Theater League. They come down. They'll pick you up. They take you back to your pickup point.
Yeah.
So it is, and they've got Mrs. Doubtfire coming. Yeah. And Juliet. So a couple great shows coming up.
Absolutely. There's a few left in this year.
All right. Let's see if Leah held in there with us. Leah, are you there? From Killen.
Yes, I'm still here.
Yay!
Yes.
Hey. What can I do for you?
Well, I have a question. It's regarding a garage door guy. He was going to install. Well, at first he was going to take down and then order and install a garage door so that it would be replaced properly. And that was on September the 8th, which is 5 months ago. He was given the money, and he's yet to do the work. And we filed a small claims, but he's fleeing from being served. So what can I do in regards to that?
Yeah, I mean, I think you've kind of, exhausted the options that you're able to do. It's a civil matter. You can contact the district attorney, but I'm not sure they're going to be interested in trying to pursue a criminal claim for this amount of money. And that's unfortunate, but they've got other things they need to do. We tell people when you're dealing with a contractor, regardless of amount of money, don't pay the entire amount up front. Make sure that you are dealing with a reputable contractor, someone that is going to come out and do the work. And unfortunately, that didn't happen in this case. But I think you've exhausted kind of what you can do. Pursue him in small claims court, and then do your best to get service. But I understand your frustration. I think that's just going to have to work through the court system, see if you can't get him properly served, and then see if he would, is even going to show up for court.
Okay, so serving them, you have to serve them the papers that say you're suing them.
Sure.
And if they refuse to take those papers?
Right. If they refuse to take the papers and you can show that they're actually avoiding service, that they know that you're trying to contact them and serve them with papers, then you can serve them by publication, which is, serve them. It has to be publicized in a paper of general publication.
I'm sorry, there is a paper of general.
Well, there are two. There's one that the Speaking Out News is the one that we use, which is local in Huntsville, and then there's another one, Madison Advisor, or I can't remember what it is, but amazingly, since there are only two, their publication rates have gone up, much higher. But there are two, and you publish it for 4 weeks, and then you're deemed to have them served.
Fascinating.
And now it doesn't mean that they're going to be able to pay a judgment, but you can potentially get a judgment for default.
Okay, we've got to go to Guntersville. Cheryl, thanks so much for hanging in there. What's on your mind?
Sure. Yes, I have a question about a car accident my husband and I were involved in. It'll be 2 weeks ago on Tuesday. There was a young man coming around a corner in a minivan just in our lane around a blind curve. We were not going that fast, but there was no way that we could avoid him. We managed to get out and walk away, but had to go to the hospital in an ambulance. They did x-rays and CT scan and discovered I don't have broken ribs. It feels like a broken rib, but a lot of contusions on the inside in the ribs and across the chest. This was 2 weeks ago, and I don't have I see the commercials on TV about people suing the insurance company because of pain and suffering. I understand now the meaning of that word, pain and suffering, but, I haven't lost a limb. I'm not in the wheelchair. I haven't had surgery. There is a loss of life in that I have lost the life that I had 2 weeks ago. I can't do anything that I did before, just waiting on all of this to heal. So my question is, given the slight injuries that I feel like I have, like what I just mentioned, I don't have, big injuries or surgeries or anything, would I be able to sue the insurance company for this young man who hit us?
Well, yeah, so the question is, there's difference between are you able to sue him and can you make a claim? You can make a claim against his liability insurance company and they will pay you for the damages that you've suffered, up to the policy limit. Policy limit in Alabama is typically $25, $50, $100, $250, $300, $500, and $1 million. But so typically what you see is a mandatory minimum policy of $25,000. More likely people have 50 and sometimes they have 100 is what you're looking at. But you can make a claim against the insurance company up to that amount. That would include compensation for your medical expenses, your pain and suffering, your mental anguish, any time that you've had off work, your property damage that you've suffered, and any permanent or disfiguring injuries that you have. So those are kind of the elements of your claim. This is something that personal injury lawyers talk about, every day. Most personal injury law firms, including mine, do free initial consultation. So what I would say is it's probably more than what you could talk about on television, but it would be worth going to talk to somebody. We would talk to you about, what is this? Does it make sense to make a claim? I think it would. And then you would look at what the situation, how that would play out. Whether this is something you need to hire a lawyer on or something that you want to try to work on yourself. We can.
But at least talk to somebody.
Yeah, absolutely. You don't have to hire anybody, and we do consultations for free.
Okay, let's try and get Sandra in from Muscle Shoals. Sandra?
Yes.
What's your question?
My question is, I was calling to see if there are any on the hernia mesh that everybody has had. I've had to go in and have all of the mesh that I had in my stomach taken out. And it cost me nearly 6 and 7 weeks in the hospital. I was in bad shape with it. But I've contacted like 3 different places that say on the television, we do this, we do that for hernia patients. But I've gotten no return from anyone.
Yeah, it's when you're dealing with the mass torts and the property claims like that. Typically, this is I think the first hernia claims came out more than 5 years ago. So a lot of those claims are way down the line in terms of people that could get compensation. The companies that were involved could be bankrupt. And that could play out. So, it's hard for me to tell you, directly, but you want to identify who the manufacturer of the mesh was. And if you had more than one types of mesh, that can make it more complicated. But if you have your records from those surgeries, that's going to be beneficial. But I'm afraid that a lot of that water is under the bridge in terms of the litigation that's gone on against those companies, and it may not be, fruitful for you to pursue the claims.
Well, thank you. We'll be right back.
Timberlake, League and Brooks, which pays an advertising fee to this station.
If you want to get a hold of Michael Timberlake, he's with Timberlake, League and Brooks here in Huntsville, 256-536-0770, or look at their website, law-injury.com.
And Sharon will be back next week. She practices family law in the Tennessee Valley in Huntsville, 256-539-7337 or SharonFamilyLaw.com.
Now, Dean was nice enough to call us.
Sure.
Someone dug a ditch. Now there's water coming on his property.
Right. So you can't, it's not legal for you to do something on your property that diverts water onto somebody else's property. And so that you can, file an injunction to get them to stop doing that and take care of that problem. The best thing we tell people is, one, get a survey. Two, go out there and address the problem with them. And if they're not willing to fix the problem, then, unfortunately, you're going to have to hire a lawyer and take them to court.
Well, thank you so much. Sharon Doviat will indeed be back next week. Thank you so much for joining us.